Good evening, everyone. If you may allow me, I would like to begin by thanking bin Rajab Cultural Majlis and Mr. Yasir Rajab for hosting this insightful event, Dr. Hasan Radhi for taking the time to enlighten us with his knowledge, and thanking you all for joining us tonight. In the beginning, I would like to welcome Dr. Professor John Willis, Associate Professor of African History, for his welcoming word.
So good evening, everyone. Hi, I'm John Willis, Professor of African History at Carleton College in Northfield, Minnesota, and really honored to be here tonight at the Bin Rajab Cultural Majlis for this occasion.
Thank you so much.
As I said, I'm a professor of African history. I'm here leading a study abroad program called History, Culture, Commerce between Africa and Arabia. It is a course that takes place over the course of 10 weeks. We are in the midst of a second week here in Bahrain. We'll be here for 3 weeks. We've already spent 2 weeks in the Emirates, and we will be in 7 weeks in Zanzibar. It explores, a range of aspects of important to Bahrain's history, the history of pearling, the culture, the exchange, the trade that took place, linking Bahrain to other sites within the Gulf, and of course more globally. We're touching on aspects such as food, dress, perfumery, which are all important aspects, of course, of Bahrain's rich history and heritage. We've learned about the antiquity of civilizations that have existed on this island, going all the way back to the Dilmun Age, and the way in which trade has been such an important part of Bahrain. We've been really delighted to experience Bahraini hospitality, and this occasion reflects that as well. And again, we're just really honored to be here and look forward to hearing the lecture and continuing this relationship between Carleton College and the Bin Rajab Cultural Majlis.
Before I start with a formal introduction, please allow me to mention the story of a full of ambition fresh law graduate that was very keen on seeking an opportunity at the biggest law firm in Bahrain, and was actually lucky enough to get that opportunity. Until this day, 8 years later and a few jobs later, considers that internship as a huge kickoff to her career, one that taught her a lot and built her both personally and legally. And today I am honored to be introducing the founder and senior associate of this law firm, Mr. Hasan Radhi. Dr. Hasan is the founder and senior partner of Hasan Radhi and Associates, the law firm. He is a licensed attorney before all Bahrain courts, including the Court of Cassation and the Constitutional Court. He works in various legal fields and handles both local and international arbitration disputes as an arbitrator and as a lawyer representing parties. He is a former council member of the Institute of World of Business of International Chamber of Commerce and a member of the ICC Paris Commission on Arbitration. He is a former member of the LCIA Court and vice chairman of Arab Users Council of London Court of International Arbitration. He is also the founding member and former president of the Bahrain Bar Society. Professionally and educationally, he holds a professional associate at the University of London. He is a former lecturer at the University of Bahrain and the BIBF, the Bahrain Institution of Banking and Finance, and he is also a member of the editorial board of Arab Law Quarterly Bulletin London. Please join me in welcoming Dr. Hasan.
Thank you very much. Bismillah ar-Rahman ar-Rahim. Good evening, everybody, and our guests are welcome to Bahrain, and welcome to our friends whom we meet on different occasions. I hope that I don't disappoint you after this long introduction by Fatima, and I hope I can do something of interest. Mr. Yasser invited me to talk about Bahrain history, which I found impossible for me, as I'm not a historian, firstly, and secondly, I found it too large for the plot of time allotted for the speech. But I agreed with him on compromise that I speak briefly about the Bahrain judiciary history. Bahrain judiciary history is not very calm and of normal development. It faced a lot of jumps and waves. But for the introduction of this history, I think it will be easier if I divide it into 5 stages. Stage 1 of this history of judiciary is for the period before the Al Khalifa rule, the rulers, the current rulers of Bahrain. And the second is the judiciary from the arrival of Al Khalifa until beginning of the 20th century. And the third stage is from early 20th century until the reforms and 20s of the 20th century. And a very distinguished era is the era of Bahrain Ordering Council, which is very interesting period and very interesting legislation as well. And finally, the establishment of modern national judiciary, which is the current system. Before Al Khalifa, in fact, all what really was dominating the judiciary in Bahrain is the prevailing doctrines of the government was mainly led by the Shiite Imamis rule. The judiciary, al-Qada wal-Hasba, judiciary and administration, was in hand of the jurist, the more superior jurist, who was elected from the jurists, the highest caliber of jurists, who are known of their knowledge in religion and their honesty. The basic of this regime is that the legislation is not a mankind creation. It is God. The law is laid down by God, and God delegated this power of legislation and judiciary to the Prophet Muhammad, and Prophet Muhammad delegated the same to his successor, Ali ibn Abi Talib. Then his sons, Ali's and Fatima, the daughter of Muhammad's sons, he delivered it or delegated it to his successors, his sons, until number 12 of them who disappeared. He is still, as the Shia believe, that he is on occultation, and one day he will appear and rule the world. And I'm sorry, I have to put this off. And during his absence, occultation, if I'm right to say occultation, is that correct? Disappearance. And in this period, his deputies, who are the jurists, the super jurists, as I mentioned, will take the role as walayat, what is known now, the prevailing title of that, as we know, is walayat al-faqih. Although this is a new terminology, but it gives the correct meaning, or at least the most accepted translation of the role of deputy imam, or the deputy of the imam, the absent imam. And the Bahraini judgment, the Bahraini judges those days were really acted as independent, as they believe that they are employed by God and not by the rulers, the secular rulers. Despite the fact that the Safavids, the Persian state of Safavids, occupied and ruled Bahrain at that period, the judges in Bahrain refused to accept any instructions, including financing from the government of Persia, the Shiite government of Iran. And there are very famous stories which we may come back to them in discussions to save time. And we have jurists, we have example for such jurist refusal of receiving instructions or even financial support from the secular emperors of Iran. The second stage is from the arrival of Al-Khalifa until beginning of the 20th century. In 1782, Al-Utub tribes led by Al-Khalifa launched an attack on Bahrain from Zubara, and they take over the rule of the country. They became the Bahrain rulers, and they have brought with them new elements of judiciary. Of course, when I speak about the domination of the Shia prior to this period, there were Sunni communities as well, but the majority, the absolute majority, was the Shia system. I mean, the Shias who followed the Shia doctrine on this. But there was also communities other than Shia who have a similar system of religious leader or religious jurist who rule and assume the role of judiciary based on the Sunnis school of fiqh, between brackets jurisprudence. The new elements of judiciary which came with Al-Khalifa is the rule of the head of the tribe, especially the sheikh of the tribe, who was the super or the supreme judge between, in any dispute between members of his tribe or his tribal alliance. And also the immigration of many tribes from the peninsula with Sunnis beliefs, and then this improved or brought more existence to the Sunnis Sharia judges or adjudicator as well. A third, later on, after a few years, when Al-Khalifa entered into or the Sheikh of Bahrain, entered into conventions and treaties with Britain, another system or another element entered into the judiciary, which was the existence of the British authorities, and who have their, of course, their own way and their own, they impose certain doctrines in judiciary and rules as well, and laws, impose their own laws as well. This was treated by the Friendly Commission Treaty in 1861, pursuant to which the chief, the sheikh, they called it the chief that time, was prevented from the rule of judge in disputes which involved non-Bahraini party. He was expelled, or he was prevented from that rule, and the jurisdiction was taken over between non-Bahrainis by the British authorities, who were appointed in the positions of judges. So in this period, the second stage, which I called it as from the arrival of Al Khalifa until the beginning of the 20th century, the forums of judiciary may be summarized in the following. The tribal judiciary, headed by the chief of the tribe, the sheikh, who then were called in a later stage, he gained the name of the ruler. He was called the ruler. And second was the Sunnis judicator, who were mainly vested with resolving family disputes among followers of the Sunni sect. Third, the Shia judicator, who were vested with resolution of disputes generally among the followers of the Shia sect, or the Shia sect. And Salifat al-Ghous is one of the very distinguished institutions of judiciary, and this was, Salifat al-Ghous was the pearl divers adjudicator, formed from persons who are knowledge and experienced in the industry of pearl diving, which was a vital business in that time. And we will see that in that stage, a new institution is started to emerge, and that was the Majlis al-Urfi, which is a trade practice council. We will talk about it in the following stages. Started at that period and then emerged until it became a form of legislation and a system which runs the countries for long. I mean the country, Bahrain. When I say the countries, because there was, we will see that there are similar majlises or councils in different places of the Gulf, but in Bahrain one was very well noted and involved a lot of discussions among different authorities in the Gulf, including the British authorities. The third stage or period is from early 20th century to the reforms in the 20s of the 20th century. The Friendly Commission, which I mentioned, laid down the basis of the British political resident, the political residence in the Gulf was in Bushehr, as what his office was in Bushehr, but he was competent of looking after the British interest in all the Gulf area. He was, in fact, the ruler of the Gulf states or the Gulf principalities those days. And in 1890, the British government passed the famous Act of Foreign Jurisdiction Act, which empowered the British officers in the region to assume the party or the part of judiciary. They were appointed as judges, but it was not organized. It's just based on general principles and without a prior legislation or formation of authorities. And this continued to be the case until the formation or until the emergence of the Majlis al Arfi, which we refer to as the Trade Practice Council. In a report dated 25th January 1906, sent to the political residents, Major Cox, the British political agent in Bahrain, mentioned or referred to this council, to Majlis al-Urf. It was in the occasion of a case involved a foreigner, a German businessman in Bahrain who had disputes with Bahraini prominent people, and the ambassador, the German ambassador to Iran was concerned, and he wrote to the political resident, inquiring about what to do, how to protect Mr. Bahanson. I think his name was Bahanson, if I am not wrong in pronouncing the name. So Major Cox, who was in Bahrain, sent to the political resident in Bushehr, telling him not to worry, because there is a council in Bahrain which will be capable to look into this dispute fairly. And he said, I'm quoting him, he said, he described the council as a prominent committee, this is his words, prominent committee of responsible native merchants appointed for settlement of commercial disputes, in which is a feature of administration of justice in Bahrain. And then connection and discussions continued on this idea of improving the council. In his letter, Major Cox mentioned that this council was half Bahrainis, half foreigners, and which gives it, and it was optional, reference to it was to optional, which categorize it, if we now talk about it, as an international commercial arbitration forum. Mr. Cooks or Major Cooks also, when I said at the beginning that it started emerging in the previous stage, he said in his letter, I mean, again, Major Cooks mentioned in this report that this forum had been in existence for the past 50 years. So that means it started emerging 50 years before 1906. We go to stage or period 4, which is based on the mainly on the Bahrain Order in Council. What is Bahrain Order in Council? Discussions after Mr. Hasan case mainly and other cases involving non-Bahrainis, the British authorities started thinking of having a kind of regulation or a law which govern the disputes in the region in general, either between the local, the natives, among the natives, I mean, among them, or between any party, any native party and foreign party, and the foreign parties' disputes among them, among the foreign parties or institutes, companies, I mean. Discussion continued with the object to have that legislation, and this reached to the existence of the Bahrain Order in Council. We will talk about this order in council. It's issued by British. The Bahraini ruler had no participation in that. It came from, it was issued by Birmingham Palace, and no, without consulting the local authorities, of course, that time. And this was published, it was enacted by the Court of Birmingham Palace on 12th August 1913, and was published in London Gazette on 15th August 1913. But it was not forced at its enactment because of the then first war circumstances, which made it difficult at the existence of Ottomans and other powers in the area to enforce that law, which is issued in Britain and not in Bahrain. Until 1919, when everything was calm and the outbreak of the war, the First War, Britain became more stronger in the region, and they decided to enforce that law or that order. It's order, so-called order. It's not even law, it's order, it's from up. So consequently, that order or that legislation was in force. The maker of this order took into consideration the existing institutions and authorities, judicial authorities. I'm limited to judicial, by the way, not talking about an other part of law, or I'm limited to just the judiciary power. they did not, the British administration did not ignore the then existing institutes. So the Order in Council, Bahrain Order in Council, had the following institutions and judiciary authorities. Number one, and at the top of the institutions, was the Chief Court. The Chief Court was presided over by the political resident in Bushehr in Iran. He was the supreme judge in the system as a whole, and this court had the absolute jurisdiction of all foreigners, whatever their nationality, other than Bahrainis, whatever the nationality is, was under his competence, and had the authority to refer any dispute he decide to the local Qadi, Qazi, it is called Qazi, K-A-Z-I in the order, in the Bahrain Order in Council. And it was also competent, this court was competent with, had a jurisdiction also as a court of appeal for the judgment issued by the district court, which is the number two, is the district court. And district court was presided by, presided over by the political agent in Bahrain. Political agent acted as the head of the district court, which the jurisdiction was over disputes between foreigners as a first instance court. Its judgments were appealable, as I mentioned, before the chief court. And number three, we said the chief court, the district court, and then the joint courts. The joint courts, court or courts, sometimes it comes in the story and book as courts, sometimes as court. The joint court, which was consisted of the political agent in Bahrain or one of his assistants, and judges appointed by the ruler of Bahrain, who was the sheikh, now he is the ruler. This court has jurisdictions over disputes which involve foreign and Bahraini parties, whenever there are foreign or foreigners, even nationals of Gulf principalities, then called principalities or emirates, or sheikdoms. There are different references to them. Sometimes the British historian like to call them sheikhdom, sometimes principalities, sometimes emirates. But we know that they were treated as foreigners anyhow, and when disputes involving them with Bahraini party was the competence of the joint court. And al-Majlis al-Urfi, the really prominent always in the constitution of the judiciary power until then the modern national judiciary organization came into existence. The Majlis al-Urfi, according to the order, was formed of at least 4 members, at least, but mostly the members were 6, mostly. But according to the order, the minimum number of judges shall be 4. Then we have Salifat al-Ghaus, which we have referred to as the competent court which has had a jurisdiction on disputes relating to pearl diving industry. And the last one was as the order called it, the Qazi court, Qadi. What it is in the publication or promulgation, it was proclamation. Was the name was Qazi, K-A-Z-I, but they meant Qadi, the judge, Qadi, and the Arabic word Qadi is the judge. And this court, Al-Qadi or Qazi judge, Qazi court, has jurisdiction over disputes involving Bahrainis, between or among Bahrainis, when it doesn't involve a foreign party. However, the chief court has had the authority and competence to refer any dispute they deem fit to the Qadi as it deems fit. This is the history until that stage, i.e. around the end of 20th century. Then the next step and the last step as a history is the emergence of the modern national judiciary system. It is really very interesting history, as it started with Sheikh Isa bin Ali challenge to the British authorities and being very obstructionist against, he had a very obstructionist attitude against the order in council and its institutes, and always objected to abide to the British administration in connection with judiciary. In 16th February 22, number of Shia leaders wrote to the ruler. They sent him a petition demanding reforms in judiciary. And Sheikh Isa bin Ali very intelligently used this petition in favoring the petitioner, or in a form, or reacting positively to this petition. He issued a proclamation in which he imposed or presented the rule of the Bahraini a new judicial system, dependent from the order in council. according to this proclamation, which was issued in soon after the petition, it was issued in 22nd, and 16th a petition was sent, and 22nd, I believe, the proclamation was issued. It was known as declaration, and the British officer liked to call it Sheikh Isa Magna Carta. And according to this new system of national, this is, in fact, it was the nucleus of the national judicial system. In this declaration, Sheikh Isa kept to him and his son the highest rule in the judiciary. It is very interesting. It is very, very nice piece of legislation. In fact, the dispute after the proclamation of this declaration, the dispute escalated between Sheikh Isa and the British authorities. They were not happy of his attitude, and they decided to abdicate Sheikh Isa, and on the grounds that he's too old to exercise his powers and his responsibilities, and they replaced him by his son, his heir apparent, Sheikh Hamad, who was in more harmony with the British authorities than his father. And Sheikh Hamad organized or cooperated with the British authorities until he succeeded to have his own court, Sheikh Hamad Court. It was, and this is in fact a very forward move towards the national judiciary system. At the stage of Sheikh Hamad Court, which is as I said, or I may describe it as a step up in the Bahrain national local judiciary, but still it had no competence to rule over all the people, or this authority was limited to the Bahrainis, dispute between or among Bahrainis. And the Gulf resident or the political resident was still in power in the judiciary as supreme judge in disputes among foreigners. Major Daley, the famous political agent in Bahrain that time, described this situation, this judicial situation at that period, as actually, that's his words, I'm quoting his words, actually based upon the merging of jurisdiction of the political agent and the ruler of Bahrain. That is exactly what was the situation. Still, of course, Sheikh Hamad Court was more competent or had more jurisdiction on commercial, criminal, and civil cases, but for family cases especially, the Shia and Sunni Sharia course continued to be active. Salfat al continued to be active as well. Partially, Al-Majlis al-Urfi was still there. But the upper rule was to the Sheikh Hamad court. At that period, during daily existence in Bahrain, daily rule, حكم daily, معروف, حكم daily.
Daily is the name, okay.
Yes, his name is Daily, Major Daily.
Daily.
Yeah, Daily is the name. Major Daily. That's I mentioned. I think. Yes.
Life.
Yes, and the idea of having an advisor became discussed between the political authorities and the sheikh, the ruler, and this yielded the idea of employing an English advisor, and that advisor was Charles Belgrave, who entirely changed the picture of the judiciary and developed it in a modern way and laid down the basis, the grounds of the new judiciary, and developed Sheikh Hamad Court to be later on as a real judicial system with different grades of litigation and with more specialization. This continued Charles Belgrave role. Charles Belgrave became the real ruler. He issued the legislations. He was the lawmaker, and he was the judge, the head of the courts. He was everything, police, everything, health, all the Bahrain affairs was in his hand. This made Bahrain people a bit objective to this, and a real movement, national movement against Charles Belgrave started, led by the... before I jump to that, the most famous law in connection with judiciary or organization of judiciary took place in 1938 by the advisor Charles Belgrave. Sheikh Hamad and certain Bahrainis leaders suggested that a new law be laid down on the Pan-Arab movement that time, and suggested that somebody to help in laying down laws and organization of judiciary from, by experts from Sudan or Egypt. But this was not very welcome by the British authorities. At this stage, especially after the enactment of 1938 law by Charles Belgrave, and dominating the lawmaking and judiciary, an opposition of a huge number of people in Bahrain started, and which was culminated in between 1954 and 1956 by a mass national movement represented by the High Executive Committee, الهيئة التنفيذية العليا, demanding independence from Bahrain and demanding reforms as well, including the reforms of judiciary based on local laws. But this committee was dissolved and its members were imprisoned, and the movement, of course, was ended. But as Dr. Hussein al-Baharna, I'm quoting Dr. Hussein al-Baharna, who is a very prominent legal thinker, not just he was the first Minister of Legal Affairs in Bahrain in early days of independence. He says, despite the dissolution of HEC, a number of legislation regulating civil, commercial, and penal matters were promulgated with slow gradual development in the judicial institutions until the independence. So since then, the Bahraini national law started to come up. Now, this is until here. I have covered the historical part, which is history past, but we have now a new and entirely after the independence in 1971, things have changed completely. In 1971, following, as you all know, the Britain new east of Suez Canal strategy, Bahrain gains its independence. Concurrently with the declaration of the independence, the judiciary law was promulgated before any other law, even before the issuance of the Constitution, which shows how the judiciary authority was and the priority of the leadership of the Bahrain government. 1971 Judiciary Act or Judiciary Law laid down the organization of courts in modern concept and with the grades and specializations, departments. When I say degrees of court, that means first instant, appeal, and in the same year, 1971, the Civil and Commercial Procedure Law was enacted simultaneously. These laws has played the most important part in development of judiciary and understanding of laws and justice. Of course, commercial laws and the procedure went concurrently with the development of civil part of legislation and judiciary. In 1973, the State of Bahrain Constitution was promulgated, and Chapter 4 was devoted for judiciary. Chapter 4, in particularly in Article 104, I will read this as a quotation. The honor of judiciary and the probity and impartiality of judges is the basis of the government and the guarantee of rights and freedoms. And as I said, in 1971, the law, the judiciary law was already or had been already promulgated. But this law, the judiciary law, was replaced by a new law, more advanced and more clear and more comprehensive. That was made by Law Decree number 42 2002 2002 with the new regime, the new leadership of His Majesty the King. The law, this law, comprehensively has organized the judicial authority and set forth the court's order, organizing and jurisdiction, appointment and promotion of judges, their duties, their immunity, accountability, termination of services. This was very clearly and comprehensively handled by the Judicial Act of 2002. Just a quick, do I have the button here? The most characteristics of this law, as I said, is to organize the courts and for the first time the public prosecution, which didn't exist, which had not existed before this law. The most important things or elements in this court is dividing the court, the category of courts, in two main sections. Sharia courts, which role is limited to family disputes, including marriage, inheritance, donations, endowment, waqf. And secondly, the court or section 2 is the civil dispute courts, which jurisdiction include civil, commercial, and criminal courts. The most important characteristic or the institutions of under this law is the organization of the Supreme Judicial Council. This is very important institution which had not known before this legislation. The Supreme Judicial Council is competent to, I'm quoting, so supervising good conduct of work of courts, propose the appointment and promotion of judges and members of public prosecution, propose the appointment and promotion of judges and members of public prosecution, give opinions on draft laws related to judiciary and public prosecution, and all matters stipulated in the judiciary law. It may be worth mentioning that in a mark of respect of supremacy of the judicial authority, the Supreme Judicial the Supreme Judicial Council is presided over by His Majesty the King. This shows how this authority is highly considered. With there is a permanent deputy president who actively run the operations of the council, the daily work of the council. Something interesting to mention in Bahrain judiciary system is going towards globalization, more international aspects, more international paths and forms. To achieve that, Article number 4 of the law of 2021 had been recently amended. Article 4 has been amended to, I'm quoting from the law now, parties to dispute may agree in writing before filing a case to choose a language other than Arabic from languages that can be used before the courts. This amendment is to an article which was limiting the language of judiciary in Arabic. The only language was accepted before the courts of Bahrain was Arabic. Now you can choose the language. The parties may choose the language they want to litigate in. But mainly, the second language was started in the courts is the English language so far, only English, in addition, of course, to Arabic. Article 22 of the same law was amended to allow the appointment of judges from any nationality. The old text was limiting the appointment for other, of course, Bahrainis are priority always, but it is permitted, it was in the old law, it was permitted to choose judges from Arab countries. But now, according to the amendment of 2023, from any nationality deems appropriate. And really, we have now judges, non-Bahrainis, non-Arab judges, sitting in special departments, looking into cases and hear submissions and pleadings in English language. I think we stop at this to save time. And by the way, just to add, a new agreement with Singapore is being discussed, but it has been declared, under which a court will come into light, which is called Bahrain International Commercial Court, which will hear international disputes, not only legal disputes. I think we stop at this, and you are welcome for any correction for me first if I am wrong in any point. First, correct me. I will welcome that if I am wrong in any of the points I raised. And number two, your enlightening by your comments and interference and ideas. And number three, if I can answer any question. Thank you for your patience listening to me.
We'd be happy to accept any questions, any comments.
Thank you so much for talking a little bit about Bahraini judicial system. So I was doing a bit of reading, and it seems you have like three separate parts in the judicial system. You have like the Sharia law, you have they have the law system for non-Muslims, and then the military also has its own system. Can you think of a time when those like three systems were at odds, or you weren't really sure which judicial system took precedent?
Yes, thank you very much. This is a very interesting question. In religious law only apply in Bahrain for family disputes only, not to any other dispute. All the other laws are based on modern system and more civil system. And for military, yes, the military has its own courts. The military courts are separate in a separate system. I have limited myself talking about the civil, where everybody is in. I have not touched that. We have also a council, special council for the disputes among the ruling family members, which I do not, I avoid talking about that because that will take much long and maybe it's not of interest of every participant here. I hope I have answered some of a part of the question. Any more I have to explain, or that's enough answer?
Well, you may not have it. I was just wondering if there's an instance where it wasn't clear which like judicial court took precedent, but it seems like there hasn't been. I don't
No,
know.
there is never. It's very clear.
Yeah.
No confusion.
Okay.
The elements of each case is very very clear to the litigants. But in case of somebody is completely ignorant and has no lawyer, the registrar or the clerk in the court will explain to him that he is in the wrong counter, and he will transfer him to the appropriate counter.
Thank you so much for your lecture and presentation tonight. One question that I had was, earlier in the lecture you mentioned how there was a separate court system for pearling and diving in the early 20th century. I wanted to know how that judicial system, how that separate judiciary influenced the commercial and civil law that we have today in Bahrain.
If I'm right, if I understand your question, you are asking how the pearl diving court affected the modern system in Bahrain?
Yes, how the pearl diving judicial system affected current commercial law.
Yes, yes. I don't see much effect of that. In fact, it disappeared since we have more clear law and more comprehensive law. Contract law is very clear. Civil code is very clear. And all aspects of contracts is organized by a relevant law, like commercial companies law, regulate companies, labor law, of course. I'm just giving examples. Law of commerce is organizing the commercial activities in general. So there is Salifa means that mostly Salifa means precedence. And precedence means the practice, the prevailing practice. That's more accurate translation of that. It has no much direct influence, in fact. And there is no pearl diving now, so even if there is an effect, you cannot touch it.
Hi, thank you for the lecture. I have a question towards the end. You talked about globalization, and there's a joint commercial court with Singapore now, right? Why could you?
Are you Singaporean?
Sorry, I'm not a Singaporean. No. Yeah, I look like. Yeah, I was wondering if you could talk more about why Singapore would be the country specifically, and or if there's other like countries that will have more commercial laws, like in progress as we go into the later 21st century. Thank you.
Well, in fact, it is too early to talk about this court. It is still under discussion. And we know that there is a draft convention between Singapore and Bahrain, but we are not aware of the details so far. But all what I have mentioned today is quoted from or taken from a declaration to the Minister, His Excellency the Minister of Justice, that discussion has been going on. The idea of the court as it's declared, or to the extent declared that a court, an international court, will be established in Bahrain, competent to look into disputes of international nature, and international is defined in the model laws of the United Nations when it involves foreign parties, or that the headquarters of the litigants are in different countries, and so on. So this court will be a first instant court. The Court of Appeal against judgment of Bahrain Commercial International Court will be a court in Singapore, which will be devoted for that, will be appointed for that role of looking into the challenges against and appeals against the judgments issued by the Bahrain International Commercial Court. This is what is so far declared in connection with this court. Did I answer your question?
Hello, thank you so much for your lecture. As Professor Willis mentioned at the beginning, we've been doing some research and learning about the history of pearl diving, and we did a little bit of a project looking into some manumission records of people who are manumitted in Bahrain, and I was kind of wondering if you had any insight about what the role of the judicial system was in the manumission for pearl divers, especially in stage 2.
Well, the pearl diving system court, I will call it just for easy reference, had no written code or regulations. It was more case by case. It may depend on precedents. It's more like common law practice. A court which look into the cases before it based on the prevailing custom, mainly the prevailing customs of that industry and the precedents. Did I answer the question?
Yes, thank you very much.
Thank you.
Thank you again for giving all those insights about different periods and legal systems. I was curious about your mentioning of the 1938 collaborations with Sudan and Egypt, and I was wondering if you could speak more to what that looked like, and if there are other points in time where, like either in the Arab region in the world, what legal collaborations might have looked like.
Yes. As I said, national movements started at a certain time, but even before that, during Sheikh Hamad time, Sheikh Hamad himself at that time in the early 20s of the 20th century, the pan-Arab movement and ideas about Arab nationalism has what was just, I would say, emerging as well. And it was appreciated by the Bahrainis, prominent leaders that time, and they suggested that to adopt even laws. It was somehow accepted by some British officers at that time, to borrow Sudanese and Egyptian legislations, laws, and to bring judges and experts from Sudan or Egypt. Sudan and Egypt were chosen for two reasons. One is because, of course, they are Arab. Number two is were under the British rule, so there is similarity in the political situation. and they were ahead in education, certainly. We know that the University of Cairo is now more than 120 years old. I think that was the idea, is to bring people from similar culture and also, I would say, under the similar power. This continued until the independence, and the man who made the Bahrain constitution was an Egyptian mainly. An Egyptian jurist helped in laying down the Bahrain constitution and many law. And until now, the Bahrain judiciary is affected by the Egyptian precedents and jurisprudence, and we have a lot of Egyptian judges and Bahraini courts until now. Did I answer your question?
Hi, thank you for your presentation. I was just wondering about the integration of new languages into the court and if it's posed any challenges to interpreting the law, especially when it comes to like translating the law in like specific wordings, or if it's changed any procedure of the court.
Yes, well, that is really very interesting. I am myself wondering what to do when we have all the laws enacted in Arabic and wrongly translated into English by the translators whose translations is published. We, maybe Fatma knows that, we in our office do not take a translator translation, we translate ourselves, because there are a lot of discrepancies in translation into Arabic. It's a very sensitive subject. And we hope that, and I'm sure the Minister of Justice and the President of the Supreme, the Vice President of the Supreme Judiciary Council is aware of this problem, and I'm sure they will come to a solution. We need a very specialized expert translators to the law. And as I told you, we in our office do not rely upon translation of translation offices, with all my respect, because it needs certain capabilities of the legal technical language, which we miss. Did I answer your question?
Assalamu alaikum. I want to raise a question. I don't know if you mentioned it earlier. I want to raise a question. I don't know if you talked about it because I arrived late. What was the legal status of Garandul, the prostitution center? Garandul? And what was the role of the British agent or the British colonial system in managing it? Thank you.
It's a risky area. It's really risky area. Yes. There is an announcement, I will say, a declaration, إعلان, but it is a piece of legislation anyhow, which was imposed as a legislation. I will say it in Arabic, excuse me, and then I will translate whatever I can translate. This law was issued by the advisor Charles Belgrave, and I think it was in 1936. If it was 1930s, and it says, I will say in Arabic, and I will translate into English. يسمح, this is what I remember of the wording, يسمح حاشاكم جميعا للعاهرات المجاهرات أن يمارسن عملهن في المنطقتين التاليتين: جبلة في المحرق وقرندول في المنامة.
جبلة في المنام.
أو بالعكس. شكرا على التصحيح، أول مرة تصلح. He's my friend, by the way, so I like to joke with him. He's a very close friend, and I like him. And yes, thank you for your correction, shukran. So this was really the... بس ايش دراك انت؟ I'll try to translate in English. This is a proclamation issued by the advisor, Charles Belgrave, I think in 1936 or around. And it says the following: شو نقول المجاهرات What's that? Anyhow, the practitioners, the practitioner prostitutes are allowed to exercise their business in the following two places. One, and we have mentioned the two, صلحني يا جعفر يا أخوك. Jibla and Manama and Garandol and Muharrak, full stop. So the reading of that is they are not allowed to practice in other two and other than two places. This is the positive interpretation. The negative translation is that it is allowing prostitution or permitting prostitution. Did I answer your question, Doctor?
I'm a bit confused. Garandul, isn't it? It means the brothel? Brothel. So how come it has two different names in Maharaj from Manama?
I don't know really. Ja'far may answer that. This is what I read. This is what I read in the declaration.
Give me, I will answer. Doctora, Grandol, it's coming from India. There is one road, it's called Grand Road. They brought the name because of India. In India, in Bombay, there is two places. One is Faris Road, one is Grand Road. Anyhow, this the place, all in Arabic word, in was in 30s, 40s, in Cairo, in Baghdad, all is in Iran, there was a Ghazwin, if you don't hear, okay? And Dubai also, in many places, was legally.
Lots of information about the brothels.
Anyhow, was, and also there is one advice I will give. Any family, anyone, ladies from village, from city, if she go there, she protected by the law, not allowed to her family to do anything for her. Okay, I hope I clear that. Thank you.
Thank you for speaking with us. I have a question about tourism. So how often are tourists seen in the judiciary courts? And have there ever been any instances where their host countries have to get involved as well? Or if they get punished in Bahrain, it just stays in the Bahraini courts?
Well, it's very clear in Bahrain that people are equal before judiciary. There is any discrimination between foreigner and local, tourist, non-tourist. If he commits a crime, then he is subject to the jurisdiction of Bahrain courts. But the legitimate tourism activity is welcome. The only, the thing which is to be warned of is committing a violation of law. Otherwise, At the contrary, I think that Bahrain much welcome tourists and foreigners. We are sometimes, Bahrainis are jealous from the foreigners are sometimes higher classified than us. So that's a fact.
Any other question?
Yes. Dr. Sausan Karimi, did you hear? We are in Bahrain. We get upgrade by British rule and law. So we cannot. This is the first in the 20th century. The British they bring Indian law and they start. So remember always, the British was good for this country. Thank you.
Can I answer that? Thank you. I think she can.
I'll just give you another example to answer what you commented. It's just as many families would go and teach the housemaid how to cook, how to clean, so they would have a cleaner house and better food. When they brought education, not because they love us or we deserve it, because we can serve them better. This is not an opinion. This is fact. I mean, that's what this is exactly what's happening in Gaza. This is the purpose of colonizing people and enslaving them.
Ramadan different, Shaban different. We don't mix Shaban and Ramadan. It was different under.
And who is providing the arms and missiles to the Zionists?
Only law in Bahrain.
This is no.
Don't mix Shaban Ramadan. It's different.
It's just the continuation. Just as we change our clothes according to fashion, the practices changes of colonialism and oppression changes according to the development in.
The lecture only history, and I just clarified something about it. Thank you.
History continues. We are paying for what happened in the past. We would not have lost Palestine if the British did not do the Balfour, Wa'ad Balfour. We continue to live that.
Thank you. For the sake of time, we're taking one more question. Anyone? Thank you. Thank you, Professor Hasan, for this very insightful session. Thank you, everyone, for joining us tonight and for your very, very, very helpful questions and comments. And thank you. Good night.